In the United Kingdom, the legislative authority of Parliament is absolute. Once a bill passes through both houses and receives royal assent, the debate is over. No court in Britain possesses jurisdiction to strike down or question the validity of that law. But a constitutional federal framework, exactly like the one structuring the modern Republic of India, operates on an entirely different premise. Here, the legislature is not sovereign. The Constitution holds ultimate supremacy. Because the Constitution distributes specific, limited powers to the legislature, any single law can be challenged on the grounds that it exceeds those defined boundaries or violates other express limits. When that specific constitutional challenge occurs, the Indian judiciary acts as the coordinate branch strictly responsible for deciding the issue. Striking down a democratically enacted law is a grave responsibility. Judges are tasked with interpreting and applying the text, not acting as a third legislative chamber sitting in judgment over whether a policy is wise. The process of judicial review is a strict, rule-bound legal process designed solely to keep laws within their technical constitutional boundaries. This flowchart represents the self-restraint rules. It is an 8-point checklist judges are required to run through before they will even consider invalidating a statute. The first and most critical rule is the presumption of constitutionality. Every law is presumed valid. The burden of proof rests entirely on the party attacking the statute, and if there is any doubt regarding its constitutionality, that doubt is resolved in favor of keeping the law alive. If a statute is capable of two interpretations, one making it valid and the other making it void, courts are mandated to prefer the path that upholds it. We see this preference applied directly in the precedent of MacLeod v. Black. Attorney General for New South Wales. The Privy Council examined a bigamy provision using the word wheresoever. Instead of reading it broadly and striking the law down for reaching beyond the legislature's territorial competence, the court deliberately narrowed the definition of the word so the statute could survive. Courts are structurally mandated to save a democratically enacted law if any legally valid interpretation can be found. Looking further down this pipeline, we find a series of strict procedural hurdles regarding who can bring a challenge and when. A person cannot object to a law's constitutionality if their own rights are not affected by it. This is the rule of standing. If a case can be disposed of on a smaller issue, courts will resolve it on the narrowest grounds possible and refuse to decide the larger constitutional question. They also generally refuse to rule on unenforced laws, or parts of a law that haven't yet been brought into force, because doing so is merely an academic exercise. The sole exception to this is Article 143, which grants the Supreme Court a special advisory jurisdiction when the President explicitly refers a question to them. Beyond these procedural steps, the final filters define the absolute substantive limits on judicial power. There is a common misconception that judges can invalidate legislation if it violates the so-called spirit of the Constitution. While emotionally attractive, this argument is legally invalid. The court must gather that spirit from the Constitution's actual written language. Unless a principle is found in the express terms of the document, courts will not strike down a law for supposedly offending an unstated ideal. Furthermore, courts are not concerned with whether a law is wise or just. If something is validly within the legislature's technical competence and violates no actual written restriction, it must be upheld, whatever a court may think of it. A technically competent but practically unwise law will survive review because the judiciary operates strictly on the mechanics of express power. Once a court applies these rules and determines a specific provision is, in fact, unconstitutional, a second procedural question arises. Does the entire statute die with it? The court asks whether the valid and invalid parts can be separated, and if the legislature would have still enacted the valid portion on its own. If the valid and invalid provisions are so deeply mixed together that they cannot be separated, the whole act dies. But if what remains after striking out the invalid part forms a complete independent code, the court will simply excise the bad portion and leave the rest standing. There is a strict limitation here. Enforcing the remaining statute cannot require the court to make alterations or modifications to the remaining words. Doing so would effectively mean the court is legislating. By separating construction from severability, courts remove unconstitutional text without overstepping into the role of drafting new laws. The mechanics of this test were defined in India's leading case on the matter, RMD Chamar Bagwala v. Union. The Supreme Court was tasked with reviewing the Prize Competitions Act, 1955. The constitutional flaw in this legislation was its definition of prize competition. The wording was wide enough to capture both gambling and skill-based competitions under the same regulatory umbrella. As this diagram illustrates, the court analyzed the activities and determined they were genuinely distinct classes. Skill-based events and gambling-based events are as different as commercial contracts are from wagering contracts. Applying the test of legislative intent, the court concluded Parliament clearly would have intended the act to regulate gambling, even without reaching skill-based competitions. The law was not struck down entirely. Instead, it was read down to apply solely to gambling competitions. The court confirmed that severability is a matter of substance, not form. It does not depend on whether the valid and invalid parts exist in different sections or are printed in the exact same sentence. The ruling demonstrates how severability enforces limits on legislative power while inflicting the minimum necessary damage to the legislature's original intent. This disciplined approach to individual laws leads directly into how the Supreme Court manages its own long-term impact. A legal system requires finality and consistency to function effectively. For the Supreme Court to overrule its own prior decisions, the previous ruling must be manifestly wrong. It's not enough for a later bench to conclude they might arrive at a different answer if the matter were argued today, as res integra. Lawyers sometimes urge clients to relitigate cases purely because an earlier decision was decided by a narrow majority, such as a 3-2 split. The court actively criticizes this as an unhealthy practice. If legal rulings shift depending on which specific judges happen to be sitting on the bench, it undermines the authority of a final court and creates public inconvenience. The Constitution remains supreme because the judiciary subjects both the legislature and itself to rigid doctrines of restraint.